morning and welcome to the Court of Appeals today. Sorry, I'm still trying to get used to this. All this stuff on the bench causes me a little bit of pause, but we are here this morning and I'm joined on the panel by my colleagues Judge John Luthi and Judge Ryan Tenney. We are here to hear arguments in two cases, but the cases are related. And I understand that we have sort of switched up the order as it was listed on the calendar. And we will be arguing, or you will be arguing Mr. Rothwell's appeal first. Is that
Yes.
my understanding correct? Awesome. And given that there are so many issues in this case and we want to make sure I would want to make sure that I will tell you that we will be liberal with the time. So let's make sure we get everything addressed and all of our questions, we will ask them. I think you both have been to the Court of Appeals before. I know it's been a while. It's been a while.
I haven't been in this room for a long time.
Me neither. But both sides have 15 minutes, maybe more, in which to make their arguments. We will ask our questions. I see, is it Mr. Harris?
Yes.
Mr. Harris, that you have reserved 4 minutes for rebuttal. That will be noted on the clock.
Great.
And then, once we're done with this appeal, we'll have an opportunity to take up Ms. Rothwell's appeal. All right. Do you have any questions before we begin? Sounds okay. One thing that I would ask is that each time you take the podium, you do enter your appearance for the record. Thank you.
All right, judges, thank you. This is Aaron Harris from Smith LC, arguing on behalf of Mr. Rothwell. As is apparent from the briefing, my client Sean seeks a new trial. Today I want to walk through first the standard that applies to that, the specific findings and decree provisions that indicate that a new trial is necessary.
Could you just explain to me just really quickly why you think you get a new trial? I mean, most of the issues that you have raised, it seems to me, could be, if there is a problem and we do decide to reverse those, it would seem like it would be better to send it back to the district court to either make new findings or to, take up that discrete issue, not the whole thing.
Certainly. And given how hard it is and how much efficiency drain there is with a new trial, I understand that, and I do believe there is a way on remand to resolve the issues on a piecemeal basis. There are several things that created a level of inequity in this matter that a piecemeal fix may not get to the equitable result that the parties deserve. And a couple reasons for that. One, there's a new judge, so that new judge would be evaluating the record statically without the ability to witness experts, witness the parties and the other witnesses testifying live. So it would be difficult to the extent any credibility issues or even equity issues needed to be weighed, it would be hard to weigh. So there's that issue. Also, the findings themselves, they took a marital estate that the parties' joint expert pegged at about $18.5 million and inflated it to $28.5 million. It's $10 million of judicially created value.
Right, but if that's error, then we can correct that error, or we can direct the district court to correct that error, and then it can do so. Why does that get you a new trial as opposed to a reversal that's targeted toward that particular problem?
With respect to that specific issue?
Right, I mean, if that is in response to Judge Christensen Forrester's question about why you get the new trial, why couldn't, if you're right about that, why couldn't we just direct the district court, hey, we think this was an error, we think this was an error, and why couldn't it just fix that without having to go through the trouble of a new trial?
I think with respect to the $10 million issue, probably most of that could be corrected with respect to error. I think, and I have 5 examples today of things that I think this Court of Appeals could instruct the trial court to just fix. So I don't have a specific discrete impact that a new trial would have with respect to any specific finding that I think this court would overturn. That, as we said in our briefing, the issues permeate so much, it was hard for us to identify each issue that needed to be fixed. I mean, it's a start to finish thing. There's a differential in timelines between when things are valued. There's a differential that, for example, the finding that Ms. Rothwell's contribution to the value of the business is incalculable. That's a finding that is meaningless.
Right, but we do that sort of thing all the time, though.
Sure.
We take rulings and we identify errors, even lots of errors, and then we send them back to district courts with particular instructions with respect to those errors. I mean, just to sort of stay on this initial question, why does that get you a new trial as opposed to an order fixing even a large number of errors?
Certainly. Well, I think, so, to answer that question, I'll go to the standard for a new trial as far as I understand it. The case that I think is perhaps the best descriptive case with respect to a standard is the Davis v. Grant County case, 905 P. 2nd 888 at 890. A new trial is not appropriate unless it is reasonably clear that prejudicial error has tainted the proceeding or that substantial justice has not been done. Now, I think it's the taint in which I would point to. For example, there are certain evidentiary rulings by the trial court that were, from my perspective, simply based on the rules indefensible. For example, the admission of expert reports over the hearsay objection. That's just
But if it turns
wrong.
out that's non-prejudicial, as the other side has argued, why couldn't we just say to the district court, fix that problem and call it good?
Well, I don't know how it was non-prejudicial. The court utilized those expert reports to create a blended value of an asset. And so the valuation of the asset is specifically based on the court's consideration of, incorporation of, and ultimately inclusion of those expert reports. Mr. Townsend's expert report, the entire thing was admitted. And then what happened was, with the created findings, issues were cherry-picked that were not testified to, were not cross-examined about, they were just picked out and then called something. For example, the dissipation. That was just, their dissipation was never discussed until the findings that pointed to, oh, these deposits don't have a destination, so now we're gonna call it dissipation.
Can I ask about,
Yeah.
about that?
Yeah.
No, you go.
I am a little confused by that. My sense from the decree and the findings are that while the expert, while there were distributions into accounts that were seen, you know, in the calculation, there was no ability to identify where to take those off. And the math doesn't make sense to me either. The two distributions totaled somewhere in the close to $500,000, but the dissipation amount that the court found was $418,000. So
Sure.
explain it to me, please.
Sure. So that issue was one of those that I was going to address as something I think the court should discreetly fix. So if this court recalls from the briefing, there was a stipulation entered early on in this case. And that stipulation said we're going to take a TD Ameritrade account, we're going to split it. Mr. Rothwell is in charge of sending the money out to Ms. Rothwell in two tranches, $250,000 by September 14th and another $100,000 by October 5th.
So I thought the value of that account was around $700,000.
It was more than that because
Oh, okay.
in the stipulation, which is on the record at page 405, the stipulation says Mr. Rothwell will send $250 and $100 to her. He gets to keep $350 himself, and he's in charge of paying the taxes that are created by the liquidation event.
Okay.
And then it will get trued up at the end. It got trued up at the end by him keeping the rest of the account. Everybody stipulated to that. But then what happened with Mr. Townsend's report was there were two line items that said, I see that Sean took out two amounts from Mountain America, $250,000, or he took out two amounts from TD Ameritrade and put it into his personal Mountain America account. Well, the $250,000 was what he was entitled to take. So he wouldn't account for it because it's separate property. And then the second tranche was, and it's, I mean.
But if it was no longer in his account, doesn't it have to be accounted for in the division of the marital estate? I mean, like when you do the line
Sure.
items, if it's no longer in, if they can't see it anymore in the America First account, how do you calculate that in his column Like, where do you calculate it? I mean, I
Well, it
think
was-
that's what I'm
sure.
understanding is the court's concern.
Well, the court's concern was based on, I believe to be, some expectation that Sean has to account for his use of his own separate property, which I don't think this court would ever expect anybody to do. For example, I hope I pronounced the name of this case right, the Laban case, 2022 Utah Act 103, paragraph 5, for example, is a recently decided case. Judge Holmberg in that case saw that the parties sold a marital asset, split the proceeds, and each side spent the proceeds the way they wanted to, and nobody cared. She started a business with it, her business. Nobody accounted for it, it was what it was. And the proceeds that purchased whatever they purchased, that was all separate property, it was done, nobody had to account for it. And in this case, that's what happened with Ms. Rothwell. Nobody tracked her $350,000. She got it, nobody cared, because that was the point. We divide this money, we use it how we want. So that Mr. Rothwell didn't account for how he used his own money doesn't now create a dissipation event.
But didn't the money go into a marital account?
It went into the Sean Rothwell account. So Exhibit 112 is the tax return for 2018. Shows the capital gains that he was supposed to pay the taxes on per that stipulation, which is on record page 105. Mr. Townsend's entire expert report, thousands of pages, was admitted as Exhibit 101. That has a specific exhibit to itself, which is Exhibit O. And that Exhibit O has those two Excel spreadsheet line items. And those two line items show money going into a Sean Rothwell MACU account. And what Mr. Townsend says is, I don't know how Sean spent his money after it got into that account. He didn't say it was dissipation, he just said, I never closed the circle. Then, that expert report, which is admitted, somehow between the time it's admitted, no trial testimony about it being dissipation, is now a dissipation event. That's the problem with the permeation of these the permeation of these evidentiary ruling errors now creates some kind of springboard for this, well, I can pick an argument from anywhere because I can tie it to something that we never talked about at trial because it's in evidence on page 968 of a massive exhibit. And that's the problem with that type of evidentiary decision-making, because now the swath of potential evidence that the judge didn't understand, that the expert didn't get to explain, just can be shoehorned into to mean anything. And in this case, it was meant to mean dissipation, which if we look at how this impacts the decision, Mr. Rothwell makes a decision with Ms. Rothwell to say, we're going to split this money and it's ours. So then he splits it, he pays the taxes on it, and then he has to give it back, all of it back to the marriage after getting it. And then the assets that he purchased with it, including a boat and a car, are also divided. So somehow, because of a misunderstanding of that one line item, Mr. Rothwell has to give his $350,000 back with no matching give back by Ms. Rothwell. Then he also has to pay back into the marriage estate 1/2 of that, in essence, when he bought the assets that he bought with it. Sorry.
I'll
Go,
follow up
you go,
later.
no, you go.
And I
first.
see I'm out of time.
No, I
we
have a
wanna
lot
talk
of
to you.
questions.
Yeah,
Can I just throw out something on the time? We were talking about this in the hall. There's a lot to talk about in this
There
appeal.
is.
So unless we tell you that we think we're nearing the end of the time, just assume
okay,
that
I appreciate that.
the clock is fine.
Thank you.
Fair?
Yeah,
Okay.
that TD Ameritrade money that was split and the money that went to Sean, you mentioned that a boat, he purchased a boat with his part. Will you list for me what he purchased with that money that ended up back in the marital estate?
There are two things that I'm aware of. Again, Mr. Rothwell never specifically accounted for each penny that he spent. At trial, we talked about, while I was presenting my case as a petitioner, we talked about that TD Ameritrade money and just in general what happened with the money. And two things that I can recall that I believe are on the record, and so I feel comfortable presenting them, are there was a 2017 Mastercraft boat that was traded in. The excess amount Sean paid for with his TD Ameritrade money, and I think the excess amount was somewhere in the range of $100,000. Mr. Rothwell also used that money to make some or all of a down payment to the Highland House that then became split. Actually, it wasn't even split, it was given to Janae. Ms. Rothwell, excuse me. And he also...
How much would that down payment be?
I don't recall. It may have been on the record with an amount, it may not have been. Because again, our position was that was just contextual evidence of what was happening since the divorce, or since the separation. It wasn't meant to account for every penny of that money. From our position, he could have burned it in a warehouse if he wanted to. It wouldn't matter. And then the third item, I believe that is on the record that he confirmed that he purchased was, he put money towards either a trade-in of a vehicle or he bought a vehicle, and I do not recall which vehicle it was.
Thanks.
Can I ask you
Yes.
about the valuation date?
Uh-huh.
I guess technically or traditionally or normally, a court will value the marital estate at the time of trial. If the court decides to use a different date, date of separation, date of whatever, the court has to make pretty specific findings about why they're changing, why the court is changing it up. Do you have any case citations, or can you refer me to any authority that says that it's an abuse of discretion for a court to choose a valuation date at the time of trial and not explain why it's choosing that date? Do you see what I mean?
I do. And I don't know that there is a case that specifically creates such a black line rule. The context in this case with respect to why the court erred in setting the trial date as the valuation date I would posit there are several. And these are all based on the same types of considerations that are in other cases. I don't have their names specifically, but we cited 3, 4, 5, or 6 of them in the briefing that we also relied upon in our findings. But there is a significant set of Utah appellate cases that recognize that once the parties begin to live their separate lives, that's an indication that the marital estate is not being contributed to.
Let me pause you there. In response to that argument, because you made that argument in your opening
Yeah.
brief, in response to that argument on page 23 of the red brief, the opposing side cites a factual finding from the district court that, quote, sorry, I'll let you get
Yeah,
there.
I'm there. Thank you.
Bottom of the first paragraph. Cites a factual finding that, quote, the parties since June 2018 have continued to be entangled financially. Couple questions on that. Question number one, do you think that's a fact finding, or do you think that's a legal conclusion?
Well, I don't know which it is, but I think it's wrong based on the evidence.
Okay, it reads to me like a fact finding.
Yes.
And if it's a fact finding, then I think you have to challenge it as a fact finding in your opening brief, which I don't see that you've done necessarily.
Well,
Fair or not fair?
I certainly think that the phrasing of this line, when it was included in the findings, was included in the findings piece. I think there were only like 4 conclusions.
Right.
So in that sense, the court, I guess, if has entered those findings, events.
Yeah, and let me just go and put the card on the table.
Sure.
I don't mean to play sort of Socratic law school professor games with this, but if you've got a fact finding that, quote, the parties have continued to be entangled financially, in order to challenge it as a fact finding, you'd have to go through all the marshalling process. I mean, it's not, we'll deal with the sort of nuance of marshalling, but you'd have to, practically speaking, you'd have to marshal the evidence. You'd have to show why this is incorrect as a fact finding. But if you haven't done that, and if we have an unchallenged fact finding that they are, quote, entangled financially, then how could it have been an abuse of discretion in the manner you're suggesting if they were still entangled under that finding?
Well, again, I should know my brief better than I do off the top of my head. But we certainly in our briefing challenge, yeah, it's page 23, A. We start the entire challenging of the trial court's errors when it valued the marital estate. And through this entire section, we talk about all the reasons why, not just the specific calculation was wrong, but why the court's viewpoint of valuing it when it did was wrong.
And I'll certainly give you that. You made a number of arguments about why you thought the district court was wrong on that. But if we're treating it as a fact finding, then it typically is affirmed, at least as far as our end goes, if there's some evidence from which the court could have found that. And the other side has pointed to some evidence from which the court could have found that, among others that they still file joint tax returns. And there were other things that Ms. Nelson pointed to in her brief. And so if there's some evidence from which the court could find that they were still entangled financially, why doesn't that end that issue?
Perhaps it would. I don't think that the finding has been challenged with respect to the equities of play, first of all, which I think are hard to quantify in here's this finding and here's all the reasons, because it's just in divorce cases and why we have so much divorce appellate laws, because you just have this big mush and black lines are hard to draw. And
But I think that cuts against you. I mean, not to push back,
Sure.
but that's kind of my job at this point, is to push back. I mean, that cuts against you in a sense because of the sort of mush that's inherent in a lot of divorce litigation. This is precisely why we give the district courts discretion about so much of what to do in a divorce. And so if you've got some factual basis from which the district court could say, hey, in the period between separation and trial, they're still entangled, then isn't that precisely why we, the appellate court, would then defer to the district court on that part of it?
Sure. Well, so let me talk about, mainly approach it this way, I guess.
Yeah, please.
And my first statement is kind of a generalized viewpoint on judicial deference, right? Deference to a trial court's findings is based on the premise that a trial court made a deliberate and objective consideration of the evidence at trial. Now, our brief is very direct in challenging that premise.
And I have some
think
questions
it's-
about that. I don't know if you want to get derailed on that right now. 'Cause
Okay, so that's the opening statement for what I'm gonna say next. The entanglement is all based on, as far as I can remember the findings and even the briefing, the entanglement is based on Sean continued to pay the bills, the parties continued to raise their children, and they filed joint tax returns. Well, every party files joint tax returns during a divorce. That's not an indication that there is some kind of continued financial entanglement. The fact that.
Can I
yeah.
push back on that just a little bit? There's a big gorilla in the room though here, right? In that the major asset of this marriage, and for both of these people, is an asset that hasn't been valued yet. So aren't they entangled until there is a determination as to what each of them are to receive by the valuation of the business?
Well,
I mean, how do they
I don't know how they would be-
separate themselves until they each know how much they get?
with respect to, I guess that would be the problem in every divorce case. And so I don't know.
Not necessarily. I mean, when you have two people who both have W-2 jobs, when they separate, I mean, yes, their salaries are still considered marital because they're not divorced yet, but you have a way to know, I guess, how much, you don't have to value this separate entity that is providing the basis for the marital asset. I don't know. I'm not making much sense,
Well,
but.
I guess it depends on what this court determines the word entangled to be. I mean, from my perspective, and frankly, the Utah State Legislature has provided a little bit of tangential clarity in this regard now that it passed the statute with respect to alimony. We're not paying alimony after separation anymore, done.
Mm-hmm.
So with respect to that, there is a level of separation now that the Utah State Legislature recognizes between separating but not yet divorced spouses. And we cited law from other jurisdictions that recognizes that same separation and recognizes that once the marital goal or the marital connection has been severed, and despite the fact that you can't sever that in one day with respect to every single connection, once those parties go like this, there is a significant interest in making sure that each of those parties is able to do their own thing, for lack of a better word. So we have the legislature saying, once you file for divorce, we're not calling that the marriage for the purposes of alimony. I'm not going to say they made it wider because they didn't, but I think that there is some trend and some indication from that expression of legislative intent as to how the legislature sees a post-divorce filing marriage. Secondly, when in any divorce case, at least that I'm aware of, once you start having a support payment, the court at trial doesn't go back and say how much money was earned from the beginning of the divorce to now, I'm going to split that in half. That never happens. What happens? The court goes back and says, you underpaid alimony and support, and you have to do a makeup payment. You overpaid alimony and support, I'm gonna give you a credit. The whole reason that is because the amount of earnings between the time of separation when support starts and trial are no longer considered splittable 50-50. And so that has to have some impact on how a trial court looks at, what am I going to do when I value the estate? And in this case.
But is that true when Miss Rothwell's, she doesn't have any income other than what is generated by the business and is until the trial, until, it's completely done, that is the marital estate. That is it's not separate. It's not separate for him. It's not separate for her.
Well, it is, because the business is one thing, right? But there was, even in this case, frankly surprisingly, the court, through its entered findings, didn't say, I don't know how much money Sean earned between September 1, 2019, when he started paying $20,000 a month, and the date of this decree. And he has to tell us, and I'm gonna split that in half.
Yeah.
So the income that she received during the time that the company was generating value and creating income, for whatever number it was for Mr. Rothwell, maybe it was a lot, maybe it was a little, I don't even know. But the point is, if you're going to take a party's gonna pay support, and that means they're still entangled financially, to its logical conclusion, it doesn't get there. Because if it did, that wouldn't be the question. The question would be, okay, how much money was earned? How much did she receive already? How much is left? 50-50 to split, and that just doesn't ever happen. So.
Can I take you to
Yeah.
the issue, unless there's more on that? Can I take you to the issue that you led with in your briefing about how to assess the findings from the district court?
Yes.
Okay. Suppose that everything else was the same in this case, except for one slight tweak. Suppose that at the beginning of the order that Judge McDade signed, he had added the phrase, quote, I have read the proposed findings submitted by Janaea, I can't remember if I pronounced that right, Janaea, and I agree with them 100%, subject to the few changes that I'm about to make. Would you still have a problem with that? Would that still be reversible error in your view? Everything else is the same. He's adopted all the other same provisions that you've faulted him for adopting. If he had just simply added the line, I've read her proposed findings and I agree with them, what then?
Well, the court basically said that after the fact, in ruling on Rule 59. That didn't change our appeal.
So you think it'd still be reversible error even if he had said that?
I think so, because the expectation for making findings is that the court make them. And one of the problems, at least from my perspective in this case, is that the appearance to anybody in the outside world, and certainly to my client, is that the judge picked a winner and just chose the winner.
But what's wrong with that? Isn't that what a judge is supposed to do, is pick a winner?
Not
choose
when
a winner?
no, the judge is supposed to get the evidence and decide what the evidence means, says, and ultimately how to
Right,
create
but if a judge, I'm not trying to be adversarial,
Uh-huh.
I'm just pushing back here, but suppose that a judge sits through a trial, whether it's a divorce trial or any other kind of trial. Judge hears the evidence, the judge is thinking through the evidence, the judge asks for proposed findings, the judge gets the proposed findings, the judge reads one side's proposed findings, and they just perfectly align with the judge's own thinking. What's wrong with the judge just simply saying on the record, I agree with those findings, that's it, that's what I think? Why would we require district courts to go through some sort of show exercise of changing things just for the sake of changing them? Why can't a district court just say, I agree with these findings, that's why I'm signing them?
Well, first of all, with all due respect to that hypothetical, I think that would be a very rare occurrence. In this case, what the judge says, I want your findings to be your arguments. That's what he said before, when he invited the findings. He said, I want your position, I want your position. And I'm going to look at them and evaluate them. And then, on paper, that's not really what happened. He entered it as proposed, with the
Yeah.
caption. The judgment doesn't even include Exhibit A. I can't go to my judgment and tell you how, I don't have a table. How did the court divide this, that, and the other? It's not there.
Okay, so let me ask the question this way, I'll come at it from the other end. How would we write the proposed rule that you're asking us to write? Put yourself in our shoes for a little bit
Sure.
on this one. If we were to write the opinion and we were to say to the district court bench, It's reversible error if you mechanically adopt the proposed findings. What's the next sentence? Is there some math component to it? You've got to change a certain percentage of the findings so that it looks like yours? I don't quite know
Sure.
what that next sentence is, and it's one of the things I've struggled with on that
Right.
argument.
And I appreciate that because, again, this is not specific to divorce law, but creating bright lines is difficult. And sometimes Court of Appeals opinions inadvertently create a bright line where there shouldn't be one, or don't create a bright line where there should be one. And that's just
Yeah.
how it goes sometimes. So I don't know that there's a specific bright line. It's kind of like, and this just popped in my head in terms of a comparison, and it's perhaps a bad one, but the old, and maybe this definition's changed, but one of the Supreme Court justices at some point said, "I know obscenity when I see it."
Potter
right?
Stewart.
Great.
Pornography, yeah.
That's perhaps what the Court of Appeals said. We look at this and we just know that some step wasn't finished.
Right, but what I'm worried about is if we say that in this context, given the ubiquity of at least the practice of asking parties for
Right.
submitted findings, if we say to the district court bench, it's reversible error if you don't deviate enough, what I suspect will then happen is that the Court of Appeals, and maybe the Supreme Court, but really the Court of Appeals, will then spend the next 5 to 15 years dealing with line drawing cases of, well, the judge changed 5 lines out of a 5-page order, or the judge changed, right? You see where I'm going with this?
Sure.
And I don't know how that rule really works as an administrable thing, whereas the other side's response it has the benefit of simplicity, which is, hey, if you think that any particular finding isn't supported, challenge the finding. Why
Sure.
isn't that the better option there?
It may be in most cases, and it may be in this case. Like I said, I think there is a way to mechanically walk back $10 million of judicially created value and about $10,000 of judicially created alimony. The court could do that. It would be an interesting set of findings to do that with the rest of the findings that are around it, because they wouldn't really make sense. It would be a whole kind of, it would just be a very strange juxtaposition of findings that are kept and findings that are changed. So it would just, but
All right,
that
so
could
how would you
happen.
write the rule? Help me with that one.
Sure.
Yeah, give me your best crack at that. How does that rule statement go?
Well, I think the rule statement doesn't need to change necessarily. The case law is that a judge is expected to do the findings. And so if a judge gets submissions from both sides, and I've submitted my fair share of proposed findings, and I've had judges enter findings that are word for word, some of mine, word for word, some of the others, in certain parts. I have never been part of a case that has just adopted them as wholesale as this. And I think the next step that this court, and unfortunately, we're all looking at I lived it, but the court is looking at a record that is bereft of the actual living of the case, and so you have to look at it. And the court is required to look at it from a deferential point of view. But at some point, there's some standard or some threshold where it's just apparent on the face of the findings that the deliberation was not undertaken. And in this case, for example, there are several indicators of that. First, the caption wasn't even changed. Second, the court, even when it was brought to the court's attention that it did not complete the judgment, the court just didn't want to do the work for whatever reason. So if a court is deliberate enough to read, understand, and agree with one side's findings, the court I would expect, at least take the step of making sure that that is a complete start to finish document from the court. And it didn't do that here. So other than that, I think the Court of Appeals can look at the record and say, to us, it appears this trial court did not take the minimum steps to indicate a level of deliberate consideration of the proposed findings that Rule 59 requires or expects. And I don't know of a better way to say it than that, but
No, that was helpful. Thank
there are indicia on this one that I think give the court something to grab onto to say, whatever the minimum is, it wasn't met. So,
If we were to try to craft a rule, wouldn't part of it, the analysis be to say that here there's a difference between ruling orally from the bench and then asking for proposed findings that put into writing what's been said orally. And here, the quote, proposed findings was really an invitation to make a closing argument. In this case, a second closing argument in writing. and that we could distinguish, and I still don't know what the rule would be, but that that a court does need to at least make the findings initially itself, orally or in writing. I'm not getting to a rule, but sounds like there would be a distinction between proposed findings that reflect what the court has already said are its findings, and proposed findings that aren't really that. It's a last argument, really.
Well, and I think there's case law that supports that. For example, the Boyer case, which is one that I think both sides cited in dealing with this argument. The Boyer case, the court, quote unquote, mechanically adopted findings, but only after the court had indicated its decision, and only after the court had allowed both sides to give the court its input on those findings and argue as to why those findings were not correct. But the court had already announced its decision first, as Your Honor has created that distinction. So in that Boyer case, that distinction is apparent. It wasn't necessarily, it didn't need to be made in that case because the facts of that case were not the facts of this case. But there clearly is a distinction in the way that findings are drafted after the fact versus submitted findings before the fact. And in this case, specifically when the court says, in essence, I want your second closing argument, put what you just said in writing, and then you put what you just said in writing, and then I'm going to look at both and see where I come down. And then the court.
But as you just phrased it just now, it does seem like the court ought to be able to come down that, you know what, I agree with this argument
Sure.
wholesale.
Certainly it could. But again, in this case, there are indicia other than the court taking its deliberate time and coming to that conclusion. Because if the court did that, if a deliberate trial court did that, it would have drafted its own caption, not left the caption on, and not left propose on, right? It would have not had those if this, then that findings at the end of the findings, which we point out in our brief. I can't remember the numbers of those, but in the 500 somewhere, the court says, well, if I decide this, then I'll do this. But if I decide this, then I'll do that. They're still in the findings.
But they were also reflected in the separate order that gave the option to sell the property, or I don't remember the details, but it did seem like that the judge's own self-created order did reflect, account for the if, then, there, and give an option to the parties. I have a different question, and that's on the valuation dates of the two businesses being different, and the factual finding that if Sean ended up getting a distribution in 2019, if I remember, that the idea that the one company's value went down would be impeached. It does seem like there's evidence in the record to support the findings there, that the 2018 valuation was not the better valuation. Will you just give me, I know you have in the brief, but
No, that's fine. I'm happy to.
Your best argument here on
Yeah.
why there isn't evidence in the record to support that
Certainly.
separate valuation date.
And here's the reason. Mr. Townsend did not rely on the projections when he made the valuation in 2019. And it's very clear on the record. So here's one of the problems. So Mr. Townsend says the projections were this, but then their distribution was that. And there's two problems. First, that distribution was based on a unicorn extraordinary event that Mr. Townsend talked about several times, where they had a legal settlement of a claim that infused cash into the company that no valuator would expect to happen again. And if your honors go back to the transcript, several times he called it an extraordinary event. So the distribution from that extraordinary event was not necessarily indicative of the company's value. Separate from that, Mr. Townsend, when directly asked, says the following. This is on 1450 of the record. And he's asked, could you just summarize or explain for the court where there was an approximate $3 million decrease in the valuation from June of 18 to February of 19? He's asked that direct question. And his direct answer is, yeah, it's pretty simple. Their revenues and profits plummeted. Not projected, their actual revenues and profits plummeted. So, looking at how the court explained its arrival to the finding that Mr. Townsend's own valuation was somehow impeached, the impeachment of the basis for, or the piece that was impeached were projections. The projections is not what he relied on. And it's very, very clear. The company's profits and revenues plummeted. And it was explained why that happened over and over and over again during the trial. Mr. Rothwell explained it, Mr. Townsend explained it, Mr. Kennedy explained it. It was never challenged. But then what happens is, by adopting mechanically a suggested argument as its finding, the court ignores all the actual evidence and adopts an argument that really has no evidence behind it. We impeached, and that word has a significant amount of meaning that I don't think applies to the question asked or the answer or how it was used, but the projections, which Mr. Townsend didn't rely on, were impeached. Okay, so what? The projections that he didn't rely on weren't reliable. Okay, but Mr. Townsend didn't rely on them. So how that then says, I'm going to just create $3 million almost of value in a company that, because Mr. Rothwell gets it at a lower value but has to, in essence, pay for the higher value, that just creates $3 million almost of marital estate value that goes specifically to a cash equalization payment. And one, I think, impactful overall note that I want to make, first of all, before we do that, did that respond to your question?
Well, the unicorn event, what was the value of that event?
It was a settlement that ultimately generated about $4 million, $3.5 to $4.5 million post-tax of cash for the company. And that was valued, that cash was used as part of the valuation of the company. Mr. Townsend said very clearly that when he was doing his income and his market analysis, the company's assets, including the value of its bank accounts, including the value of the money it received from there, were part of the foundational value of the company. So, not to get too far off track here, but when a business valuation expert does a valuation, that expert first looks at what does the company own? That's just a bottom line number, right? If you're buying the company just for its assets, you're going to pay X. But does the company, with those assets, generate revenue as well? Yes. How do I generate an approximation of the value going forward of that on top of what the company already owns? So that unicorn or extraordinary event value was already captured in Mr. Townsend's valuation. And so then, when the projections, which did not include that extraordinary money, were made by the company, those projections were made independent of that because they would not expect to have another one of those. And Mr. Townsend agreed with that methodology. But then this discrete conceptual question of, well, if you make projections that says your profits are going to go down, but you distribute more money, does that impeach that projection? Well, yeah, it does. Okay. In a vacuum, sure. But that's not what happened in this case.
Thank you.
Okay.
Okay, I think we're, do you
If I
have
can-
any other questions?
No, I don't.
If I can just make two more, or I'll just save them for rebuttal. I appreciate your time. I know I've gone, for me, it's going fast. I don't know, maybe for you guys it's not, but I appreciate the questions and I will cede my time.
Thank you for your answers.
Thank you, Mr. Harris. Ms. Nelson.
Sorry, I'm just hesitating because I'm not sure how to respond to things that he's going to bring up in rebuttal.
True.
Well, I mean,
I mean, I guess,
you're correct in your worry. We've gone so far over, I think we're probably limited to
Yeah,
issues
Sure.
he's raised already.
That's fine.
Issues that-
It's nothing outside.
Or
of
unless you raise them yourself, does that sound right?
Yes.
okay,
That's
thanks.
his response to you.
And that
Sorry.
was a fair point of clarification.
Yes,
Thank you. Sorry. Julie Nelson for Abilene, Janae Rothwell.
Maybe you can start with it didn't appear to me that the court used two different valuation dates for those companies. I mean, it was based on the information that the projections did not turn out to be. But I am a little confused about the input of the settlement money.
Well, let's back up.
Okay.
It's really common to have multiple valuation dates, right? And Townsend himself had multiple valuation dates in his schedule. And, like money that comes up during some things are easier to value than others, right? So you can value a bank account on the day of trial, but you have to value a company before that. So Mr. Harris had argued in his brief that having two different valuation dates is inherently bad. It's not. That's fine. The question is whether there's a good reason. And the good reason here was that the court, using Townsend's testimony, thought that these were the more accurate numbers. And I think we're making this way too complicated.
Can I pause you on that? And the following question might reflect my misunderstanding. There's a lot of moving parts to this case. What I got from the briefing on that issue is that the court said that with respect to one of the companies, it was going to choose a particular date to maximize its value because the company had started losing money in the subsequent years. And that was different from how it approached the other company. Do I have that right, or am I wrong on that?
Well, my understanding, and again, there's a lot of moving parts, and one of my complaints in general is that the factual findings haven't been challenged in the way that would help me and you walk through exactly what the problems are.
Right.
But my understanding is that the February 2019 value of logistics had accounted for the settlement money. The June 2018 SCS valuation was higher than the later one because it was anticipated in February of 2019 that that business was going to lose money. Now, those are the
Yeah, that's a better way of framing what I inartfully framed just now. But if that's right, one of the things that struck me about that as I was sort of grappling with that passage from the ruling is that it feels like the court is kind of putting its thumb on the scale, trying to find a valuation date that is the highest valuation date.
No, I don't think so, because based on Townsend saying, well, if it turned out that he took more distributions, then those numbers would be impeached. In other words, Townsend explained what his assumptions were and said, here are the soft spots in my analysis. That's exactly what we want him to do. And then we want counsel to come in and push on those soft spots and see if they test it out, right? That's the key, is that Townsend had said if he takes a bigger distribution, then those projections would be impeached. And he did. He took a bigger distribution. And Mr. Harris hasn't even brought up that distribution. Now, he said we didn't rely on those projections, but that's not what Townsend's testimony says. So in my view, this is exactly how the situation is supposed to go. And we're supposed to look for the weak spots and, identify what the better analyses are.
That's helpful, thank you.
Anywhere else you want me to go generally? I mean, I think big picture, we're looking at a very discretionary case. All of these things are discretionary. In fact, we've talked very little about law so far today. And I think that Mr. Rothwell isn't happy with how the findings turned out. And so he's trying to say that that was an abuse of discretion. But his arguments would create new lines. And in some cases, those lines are the opposite of what we already have. The valuation of the date of trial being the most obvious one. That's the default. You don't have to explain why you picked the date of trial. If you're going to pick another date, you do have to explain. But there isn't a case in Utah that says you have to pick the date of separation. And in fact, the cases where they do pick the date of separation, the facts are usually much more significant here. And in terms of separation, this is just, the numbers are big, but it's just a run-of-the-mill case. Mom keeps raising the kids, dad keeps going to work, dad pays her some temporary alimony. This is nothing extraordinary. And
I'm going to take a stab at questions on the law.
Okay.
And that's to go to the alimony. And there's a couple of categories that I wonder how our Supreme Court case law plays in. And one is the money for missions and college expenses. And under child support, the court, once the child is 18, typically you don't include child support, although you could up to age 21. This court has a case, Farnsworth, from 2012, Utah App 282, but where the trial court said this child has a pony, and we're going to include in alimony money to take care of the horse. And the Court of Appeals said, no, that's really child support money. You can't tuck child support under alimony. To me, it looks like we're requiring, with the mission money and the education money, requiring dad to support adult children and taking that child support of adult children and tucking it in under alimony. Tell me how legally we can do that.
Okay. First, the college-age student issue is not preserved. They didn't challenge it at trial, so let's just keep that in mind. But to answer your question, the question on alimony is whether a person can prove their needs, and that is made very, very clear in Knowles versus Knowles, which came out last March from this court. And Knowles versus Knowles really clarified that all we're really trying to find out is, did you actually spend it? Was that what your marital standard of living was, that you had paid for that? And can you support it? And
How would we square that, though, with if the need is for supporting a child support is where we handle that? And we can't say, well, we've got the child support number based on the statute, but historically, we've supported our children more, so we're gonna tuck more child support under alimony. I think that Farnsworth case says, no, in the area of child support, you don't just show historical practice and need, but we've got a statutory scheme that tells us child support.
That's true, but that's child support. This isn't child support, precisely because these children are over 18. So child support isn't part of the analysis. We're only asking about alimony. And alimony is, what are her needs and what did she spend money on? And she spent money on that. Now, I think the argument that I would expect Mr. Rothwell to make is that, well, those kids aren't going to be on missions forever. Okay, file a petition to modify. Once that
I agree
expense
with you.
drops off, file a petition to modify, right?
Can I stop you on that, though? Because with respect to both the missions and the college issue, what strikes me as unique about both of those is that there's something of a bounded term on both of them. I mean, a mission ends at 18 months or 24 months. College ends when a child leaves. And so I took his argument on those issues to be, in part, that where we know that this particular expense is going to end, at a bare minimum, the finding has to say, you pay this amount of alimony linked to this until this stops. Like if the kid leaves his mission halfway through, then it should say in the decree that portion of the alimony goes away at that moment. Same thing with college. Why is that not a problem that the decree doesn't already say that?
To be perfectly blunt, that was the argument I made in minor, and I lost it. And the argument that I made in minor was that he was being obligated to pay her student loan payments, and those had a fixed term, and we knew they were going to end. And I lost it on the basis that when they ended, he could file a petition to modify. So my understanding is that the law in Utah is that we find out what those expenses are, we box them in, and when they end, you can file a petition to modify.
I will reread minor. It's been a while.
The student loan part, I think that's the answer to your question.
Okay.
Okay.
What about I don't know if we're gonna move off of alimony, but attorney's fees, is it the same? I mean, the way, unless there is a petition to modify, it seems like the award of attorney's fees was kind of backed into alimony, right? And can the court truly consider attorney's fees that were not paid during the marriage, right? Like this is
I feel confident that Janae would love nothing more than to have her share of the estate in her hands so she could pay off her attorney fees and not have that monthly expense anymore. But she doesn't. And Sean has gone out of his way to make sure that she doesn't. And so as long as she can't pay her attorney fees, then yes, she's got a monthly payment on her attorney fees. And Sean's also sued her for defamation. Her attorney fees are through the roof. He's brought this appeal, right? Like they just keep going. Now, the court could have simply ordered Sean to pay the attorney fees, and probably everyone would have preferred that. But that's not what happened.
But pushing back on that argument, though, what feels at least potentially problematic to me about this is in the attorney fee context in particular, we've got a rule and we've got case law about awarding attorney fees within a domestic action. And if we now countenance a district court saying, well, I'm going to sort of put that rule aside, I'm going to put that line of cases aside, and I'm instead going to fold it into alimony. I wonder if we're then going to swallow the rule, quite literally, and if this is just now going to be done under alimony. And that feels off to me in a scenario in which we have a directly applicable rule. Help me with that.
If this court were to reverse and say attorney fees can't be treated in alimony, if you want the person to pay the attorney fees and you have to do it in an attorney fees award, then, I mean, that achieves the same purpose for Janae. And actually it enables her to ask for attorney fees on appeal. And that may be a reason that courts don't do it that way, because they may want to just have it be more fixed, right? It's
Right, I mean,
$5,000 a month or
It's
whatever
almost
it
got
is.
shades of like the occupying the fields doctrine from civil
Yeah.
procedure. I don't want to go too far there because I'm not an expert on that doctrine, but I know it exists. But it just seems like if we've got a rule that addresses this issue, doing it under alimony potentially subverts that rule process, that line of cases, and I find that troubling. I'm trying to work.
I see your point. I mean, I think the reason that it happened this way is because Janae listed on her financial declaration that this is what she was paying every month, right? And I assume that was because that was the arrangement that she had made with her lawyers because she wasn't the moneyed party. So she lists on her financial declaration, this is what my expenses are. And the court says, yep, that's what your expenses are. I agree. I'm going to award you alimony because you've proved your expenses. And that's really all that the alimony analysis asks. Now, if we were to break it off and say you can't include attorney fees and alimony, you should remand here to give her directly an award of attorney fees.
Or at least
to
litigate it.
analyze
Analyze
it.
That rule,
I mean, okay, that doesn't give me a lot of heartburn.
Ms. Nelson, do you have the same lack of heartburn on the defamation case attorney's fees? That'll need to be handled in the defamation case. Let her request attorney's fees there. You can't back that into a divorce action, your attorney's fees in your defamation case.
Well, that's a good point. I mean, I guess that's saying everybody needs to be, every case needs to be handled separately, but that sort of goes, I don't know, I maybe have more heartburn over that specifically because paying this defamation thing, that is one of her ongoing monthly expenses. It's not under the occupying the field language that Judge Tenney's talking about, where we're talking about attorney fees for the divorce, right? And
we do have good case law that says when attorney's fees are available and when they aren't, and what kind of actions. And you're kind of setting up an incentive that, well, if I get sued for defamation by a husband, all I need to do is file for divorce, and I may get attorney's fees that I wouldn't otherwise get, because we'll just put them under alimony. I mean, it's a rare circumstance where you've got
that
husband
doesn't seem
suing
like a
wife.
very likely scenario
But-
to me.
But the idea is, we have law that says when you get attorney's fees
Yeah,
in a defamation case, and that you probably wouldn't, frankly. But here, well, we'll say it's a part of the ongoing marital expense, and so we're gonna back it in the back door into alimony. To me, that it feels just as much like, look, we've got other law that takes care of attorney's fees.
I see your point. I do think that, under the current alimony rubric, this isn't precluded. And so the trial court, this would be a new rule, right, to say you can't include attorney fees in alimony. We don't have case law that says that right now. This would be a new rule from this case. Right now, the only rule is, can you prove it? Is this an expense that you have? And in the defamation case, I mean, your hypothetical is one. Another hypothetical is, can I just drown her by suing her for defamation while I'm at it, and she can't possibly get attorney fees while she's working here? I know she can't afford it, and then I'm gonna stay everything so she can't have any money. I mean, that seems at least as likely of a scenario. So that I can see that being abused the other direction.
Right, but wouldn't the place to litigate that, though, be in the defamation case? Because in theory, if he's filed a frivolous defamation suit against her, she can file a Rule 11 motion in that case, and she can request whatever sanctions in that case are available in that case. So why isn't that the answer there?
It may be, but what I'm saying is that we don't have that law yet, right now.
Right.
That's not our framework right now.
And just a quick clarification. My concern about the attorney's fees is not that it's an expense that she has. And when she filed her
Clearly.
financial declaration, it was clearly an expense, and it's a need that she has currently, right?
Still.
But my problem, or my question is, does that need to be tied to the marital standard of living, right? This wasn't an expense that she had while they were married. This is only an expense that arises once they're going through a divorce. So for alimony purposes, do the expenses have to be tied to the marital standard of living?
Right, and your question really is the marital standard of living when they were still living together, or something that has arisen during the course of the separation?
Right.
And I do think that the case law is flexible and broad on whether we're talking about like on the day that they were married or now? Have new needs arisen? Other needs have arisen, right? For example, maybe
Housing, right?
yeah, right, exactly. Like we didn't have to have separate houses, but now we do, right?
And the law accommodates.
Absolutely. And so I would put this into that same bucket.
Can I take you to the goodwill issue? Unless, do we have more on
No,
that?
please.
Okay.
I
This
have
was-
questions about the goodwill issue too.
Yeah, maybe they're the same, we'll find out. You've made an argument, I thought fairly persuasively, that the district court at least had a basis for disregarding Mr. Townsend's valuation at 38%. But I was a little bit less convinced that you had then identified what the factual or record basis would be for the number that the district court got to.
Right.
Help me with that. What's the evidence from this record from which the district court could point to and say, this is where I get to 18%? What's that evidence?
Right. And to be candid, that number's not in the record. Mr. Harris is correct. That number's not in the record. The question is whether it has to be. Whether a judge is only allowed to pick a number that has been presented, or whether with something like personal goodwill, the judge is allowed to say, boy, I really think that's inflated. I think that's like twice inflated. I'm only gonna give him half, which is what happened here. And I don't believe that the case law requires that every number, and we're not talking about like alimony now, right? This would be every case that where an expert gives a number. Is a judge only permitted to pick a number that's in the record? And I don't think that that's.
Yeah, one of the ways that I was thinking about this, I anticipated that would be your answer. And it feels to me like it's almost got shades of sort of reasonable inference case law.
Exactly.
You know, whether it's in a criminal case or a civil case, there doesn't always have to be a witness who says the precise thing, but there has to be a witness who says the thing from which you could draw the reasonable inference of the thing.
Exactly.
And so here, if there was even something from which the district court could point to and say, well, somebody sort of pegged this in the between 15 and 25%, or if somebody had said something like that, then maybe we can use that as the jump off point and say, well, okay, the court's sort of reading between the lines, but the lines are there, so that's how we get to 18. But I'm not even sure that I see that. It just feels to me like the court didn't like the one number and then just said, well, I'm gonna come up with another one. And I'm not sure that the court can do that.
I'd say the other number was 0, right? It's 0% goodwill, or it's 38%. You know what? Neither of those are right. I think it's in the middle of that. I'm gonna pick the number that's in the middle. And to me, it feels like, you know, an expert says something's 5 million, another expert says it's 7 million, and the judge is like, I think it's 6. And that, I think, is where we get this half number. I mean, if you come up with some completely random number, like 23%, I don't know, I think your argument would be a little more persuasive. Like, how'd you get to 23%? I still think it would be inside of the judge's discretion to say, this doesn't feel right to me.
But is this really discretionary, though? Because, I mean, we're talking about what I think would be a fact question of what percentage of this is attributable to him. So why is that figure discretionary at all as opposed to being a fact question? Or am I wrong?
Oh, no, it is a fact question. I'm sorry. The way that I said that, yeah, I was wrong.
I mean, I understand what you were saying, but
Yeah.
but if it then is a fact question, aren't we back to the same problem? Of what's the record testimony that gets him to that fact ruling?
No, I don't think that that's a problem.
Yeah.
And the reason I don't think it's a problem is because, first off, personal goodwill is a developing area of the case law.
I agree with you
Let's
on
say
that.
that.
Yes.
And we don't have a lot of anchors for
Absolutely.
trial judges, right? And in fact, my understanding is that the way that experts are valuing personal goodwill is also somewhat amorphous. Mr. Townsend testified that he used a model that's been around for a long time, all true, and he had these inputs. But again, some of those inputs were based on assumptions that the trial court found to be wrong about who was making the contract.
So given the discussion that we've been having, why wouldn't the appropriate thing for us as the appellate court do, I don't know how to finish that sentence grammatically, why wouldn't we just say to the district court, why wouldn't we remand and say to the district court, show your work on this, justify the 18%?
Well, that would be fine. Certainly, I would not want a new trial over that, right? You can make more findings to tell
Yes.
us how you got to 18%. That's all right. I mean, I personally have worked on other personal goodwill cases where the judge says, I think it's 5%. I think it's 20%. And I guess the question is, are we going to now start having appeals where we're like, no, that number's wrong. But if the issue is you've got to show your work and we remand it and the judge says, well, my other choice was 0 and that didn't make sense. I think it was only half.
Right, but
Well,
then,
couldn't-
what, Can I?
Yeah, sorry.
Can I finish on that one? Because I'll lose the thought. But then it strikes me that we have the problem that Mr. Harris has identified earlier, which is in an ordinary case where we still have the same district court judge, we could say to that district court judge, show your work on the 18%. But where we've had the judge shift over here, we do have something of a unique problem where if we say to Judge Peterson, justify the 18%, Judge Peterson may have no idea what was in Judge McDade's mind or how he got there. And so I think that will be his response in rebuttal to the point you just made, which is Judge Peterson can't do this thing. So this is why I get a new trial wholesale. What would your response to that argument that I just constructed for him be? 'Cause I suspect that's what he's going to say.
My response is that I'm not familiar with any case law that says you get a new trial just because we have a new trial judge.
Yeah.
Right? I mean, we have a record. We have the transcripts. He can go back and he can read them.
Couldn't your other response also be that we do have case law that says you can assign a value that's within the range of values supported by the evidence? And that, as you said, the range here is, what, 38?
To zero, right.
To zero. And so we don't need to justify why we landed where in the range, but that's the range. It's 38 to 0.
Right.
And you've got case law that can support that.
Right. And I think it's important here to, the whole expert situation is interesting in this case. The parties had a joint expert. There were certain aspects of what Townsend did that Mr. Rothwell decided he didn't like, so he hired new experts to come in and, discuss that. I guess a question, if this court remands to say you've got to have a actual number in there, is do we just get more and more experts to come in and say, I think it's 15, I think it's 20, I think it's 25, so that all those numbers are in the record? Or do we trust the trial judge to take the evidence that he hears and say, that doesn't sound right to me, and make a factual finding? And I think that's the state of the law right now, that we trust the trial judge to make that analysis. The trial judge doesn't have to buy what the expert says. Absolutely not.
And the expert in this case did explain why he
Right.
didn't believe the 37% or 38%, why he thought it was a different percent.
Right, and then we have this other testimony that comes in and says, you know what, actually all these other people are providing contracts. Sean's not as important as he thinks he is, or as he told Townsend he is. And you're like, okay, that seems really important here. If there are no further questions, I would ask this court.
I do have one. I do.
Not so fast.
All right.
Sorry. All right. It's not a super long question. I just want to pin down the answer. I suspect I know the answer. On the Heber home, there's been much argument about the state of the record about the Heber home and the loan that purportedly came from one of the companies.
Yes.
And one of the arguments that you had made in response to his arguments on that was that there's no evidence in the record to support the existence of the note.
Right.
And I'm not totally sure that's right, though, because you have Sean testifying under oath that the note exists. Why isn't his testimony alone under oath at the trial at least a sufficient record basis to establish that the note exists? Why is that not
I think
right?
a more important point may be that it doesn't really matter. All property acquired by the parties up until the date of divorce is marital. Dahl says that, like, that is the foundation. Okay, he bought a house. He used company money, he bought a house. It's an asset. And, maybe the note doesn't matter. The judge felt like it was important, but I'm not sure that it does matter, It's property. He acquired it. Apparently the company was doing well that year and he bought an asset with it. That's great. We're happy for him. It's a marital asset.
Well, and if it was company money that was used for the down payment, even if it was a loan, that's another mark on this ledger, right? Like from the business. That's an asset of the business. If there's a receivable, right?
Yeah, right, yes. But I guess the point is more, in my view, like, great, the company was doing well, you took a bunch of money out of it, you bought some stuff. It's marital property by virtue of that action. Therefore, it's divisible. I think it's not right to say that, oh, we're separated, what's yours is yours, what's mine is mine, and I have everything. I can do whatever I want. I can take the money out of the company, and you can't. You get $20,000 a month. Too bad for you. That's not consistent with any aspect of equity. To the extent that there's an equity question here, I think that what the judge has done is perfectly reasonable, and in fact, had he not done that, we might have appealed it, because that would not make sense, I don't think.
That was my question there.
we would ask you to affirm, not grant a new trial on the basis of cumulative error. We don't think there are any errors, but certainly if there are, they should only be discrete remand issues.
Just briefly, with respect to the preservation assertion, Mr. Rothwell's alimony arguments were preserved all over the place at trial. Appendix B to his proposed findings, record 920 to 921, specifically address what the standard of living was according to Sean and his argument. The fact that Mr. Rothwell didn't get a second chance before the decree was entered to say Janae's.
What about on the college issue? Because at least that's what I have in my notes, is when Ms. Nelson brought up preservation, she was specifically talking about the college issue.
Sure.
Did you preserve that, and if so, where? And I know I'm putting you on the spot, but.
No, that's okay. It's in the same, both sides make an argument with respect to what is part of the marital standard of living, right? The financial declarations that included this college expense, that I will note had absolutely no documentary evidence, and Mrs. Rothwell didn't testify as to how she got that number, it's just a number. But that financial declaration was part of the record. So Mr. Rothwell, in presenting his proposed findings with respect to the standard of living, said, no, you don't get that, here's the standard of living. And it's the same as Mr. Townsend's.
But doesn't he at least have to preserve the argument that you're making now, which is you can't award as part of the alimony order college expenses given that they're adults? I mean, why doesn't he have to say that to preserve that particular argument? Or something like that?
Well, again, I don't think, and this is briefed in the other appeal we're about to start to, the issue has been resolved. The specific arguments that you may or may not have had a chance to make, I'm not really sure how counsel or my client would have divined that we had to make an argument based on the Ferguson case, which is pretty clear case law that says you don't compel somebody to pay adult expenses. I don't know how we would divine in submitting a set of findings that is contemporaneous with the other side's set of findings, that we have to now address potential inclusion on their alimony number that we've not seen before. That argument put into paper with yeah.
Weren't those expenses listed on her financial declaration?
They were, and the arguments in Mr. Rothwell's proposed findings were that her financial declaration is not credible, it can't be relied on, it's not supported. So we addressed why the financial declaration.
But isn't there a difference for preservation purposes between saying this is not a credible amount of expense versus saying legally you can't award it because you can't award it based on expenses for adults? Aren't those different things?
With respect to, yes, those two arguments are different. But when Mr. Rothwell presents his proposed alimony calculation and excludes those adult expenses, his argument is those don't come in. We don't have to then say, by the way, Judge, there's this Ferguson case out there that says you can't do it. We just say you can't do it. Our argument's preserved. And then when it's awarded, we ask the court to revisit that finding, and we made the argument in our Rule 59 motion, and the court said no. So the minute we had the ability to address that discrete position, we addressed it. And it's certainly been preserved for this case. But with respect to what Mr. Rothwell's position is on what is a standard of living expense and what Ms. Rothwell's position on what is a standard of living expense, that issue has been preserved for appeal because both parties made an argument with respect to that. How the court ultimately makes the determination, neither of us is going to know until the court makes it. So it's hard to argue. For example, had the court said, submit your proposed findings and then 4 weeks later, submit a counter-propose for the other side, address those. That happens often. And in that case, we would have had the opportunity to go through line by line and say, no, 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 for all the reasons we did in the appeal. But we didn't get that chance this time. Okay, so with respect to attorney fees, Cannell, 30-3-3 and Rule 102 all say you can't do what happened. All of them.
Do they say you can't do it, or do they just
Yeah.
provide a different avenue for doing it?
No. The exclusive route for a party to seek attorney fees in a divorce.
Do they say exclusive? I don't mean to be
No.
pejorative there,
Yeah.
but do
Cannell-
they say that?
Cannell's not going to say that because Utah law says when you have a specific rule versus a general rule, the specific rule always governs. You can't take an alimony analysis and say, I'm going to eschew all of Rule 102, Rule 30-3-3, and all the case law that says you have to show reasonableness of fees first, an inability to pay, and the other side's ability to pay for ongoing litigation, divorce expenses. You have to
But
show
in
that.
theory, if the court does it under alimony, you can make the same argument. You could say the alimony award was unreasonable because these were unreasonable fees, couldn't you?
Well, you could, except that doesn't make any sense under the way Utah law works. Why? If there's a statute that addresses relief, a trial court doesn't get to just come up with some new way to address the relief. It just doesn't work. So when Utah law says, if we have a specific statute that says you have to do X, Y, and Z, or else you don't get it, you can't just go for it somewhere else. It doesn't work. Then, there would never be any precision with respect to any claims. You could just pull them out of nowhere. So has there been a case that says you absolutely cannot use alimony to pay fees? I don't believe there is. My guess is because it's not been done, because the statute's very clear as to how you do it. With respect to the goodwill, the discussion now is, well, there's a range. There's no range. There's 37.87 or 0. That's not a range. There is personal goodwill at this number, or there is no personal goodwill. There's not like there was some competing expert out there that said, I don't think Mr. Townsend's analysis was correct. Here's the way it should be. And they pegged that at 10%, and the court says, I'm going to split the difference. That's just as arbitrary, frankly. Splitting the difference is just as arbitrary. But at least you'd have some range to tie to. To just say, yes, there's goodwill, but I'm going to pick my own number is just saying, yeah, there's a house. I'm going to value it myself. A trial court can't do that either. A trial court can't just say, I have one appraisal of $2.5 million. That's all I have, but I don't think it's worth $2.5 million. I'm going to put it at 3, or I'm going to put it at 2. A trial court can't do that.
But
under
can't
any
the trial
circumstance.
court reject the expert evidence? And so let's take your house hypothetical.
Uh-huh.
Let's say the trial court says, I don't believe that appraiser is right when they say 2.5 million. You get 0 for the house.
No, the court
I'd
would-
love to give you $1
Sure.
million, but I don't have a range. It's
No.
that or 0.
The court would say, sell the house. That's what the court would do. I don't have evidence of a value, so sell the house. Happens in divorce cases all the time, especially with personal property. I don't know how much your china's worth. Either have a lottery and pick one or the other, then the other person picks one, or you go sell it on.
So should
As
the
a process.
business have been ordered to be sold in this case?
The court certainly had that ability to do that, but it didn't. What the court can't do is just come up with its own number. You have to have some basis to value something. And it's convenient now for Ms. Rothwell to say, I disagreed with Mr. Townsend's valuation number, but she didn't bring an expert. She had just as much of an opportunity at trial to bring an expert to say the goodwill number's too big. She didn't. If we went back to trial, it's not like she'd be able to get some new expert. It's the same disclosures, it's the same evidence. The court would be confronted with the exact same positions. And so there was just no range. It's not like 0 to whatever is a range. 0 is no.
So if we send it back for additional findings and say there isn't a range, trial judge says, well, I don't believe you're expert. You're good with it coming back with the business being sold.
Well, no, in that sense, the court would have to say there's no personal goodwill. The court would have to say none. Look, if the court had said, I understand what Mr. Townsend said, I understand the methodology, I just think it's garbage. Cuckoo science, voodoo math, whatever, 0. The court could have done that. But what the court does is say, I somehow am going to take improper, I may add, impeachment evidence that was presented days after Mr. Townsend. Mr. Townsend had no chance to consider, deal with, talk about whatsoever. I'm going to use that in my, in essence, case in chief to say Mr. Townsend's number was wrong by half. That is as arbitrary as it gets. A court can't just split a number. It just can't. The law doesn't allow that. If it did, then really we wouldn't really need experts. Everybody would just say, I think it should be this, I think it should be that, and the court would say yes, no, or in the middle. That's what would happen, and that's not the way this works. And personal goodwill, I disagree it's developing. It's been around a long time. It's not some kind of new valuation method. Mr. Townsend's used that for years and years and years and years. And courts have relied on his personal goodwill analysis and many others in many cases. And the personal goodwill valuation is a required element of any business valuation in divorce. That's what the case law says. So it's not some new idea that I cooked up with Mr. Rothwell to get a discount. It is.
I don't think that was the argument Ms. Nelson was making, that that the concept of goodwill was new. I think the argument she was making is that there's some fuzziness to it and that the case law is underdeveloped.
Sure. Well, I don't know, that was what I don't think the case law is underdeveloped. It's very clear that a trial court, if presented with evidence of goodwill, has to consider it. It may say, I don't believe you have goodwill, but it can't just decide, I'm not going to consider goodwill.
Right, but the underdeveloped component of it, as I understand the argument, is that it's underdeveloped as to how to ascertain exactly what the percentage of goodwill is.
And if that's the case, which I don't believe it is, but if that's the case, then Janae, Ms. Rothwell, has the ability to bring an expert to show that Mr. Townsend's methodology was incorrect, which is what we did when we brought Mr. Kennedy in to say you should have done this and you should have done that, and the trial court disagreed, and so be it. The trial court disagreed. But what is innately kind of as an overlay, when you have experts and you have pretrial disclosures, everybody can make an expectation of, okay, what are the ranges of outcomes here? And when a joint expert is retained, and the joint expert says, here's the value, when you're making a decision as to, do I go to trial at this value, what you don't anticipate and what you can't anticipate and what you can't strategize about and prepare for is just some other number that has no evidentiary basis. And that's what happened with many of these. With respect to the attorney fees, one more argument I wanted to make very briefly in rebuttal was the Rule v. Rule case, paragraph 15 is very clear. The standard of living is based on the standard of living at the time of separation. That's the rule. It's very clear in paragraph 15 of that case. You don't use that standard of living when there has to be a reduction in alimony across the board because you have to share the pain. Then you have to make judgments as to if wife's standard of living is $4,000 and husband's standard of living is $6,000, but there's only $7,000 of money to cover those, how do we get everybody on the same page? That's when you take consideration of what the realities are now. And I think with respect to my ability to make rebuttal arguments, which I apologize to Ms. Nelson, that was not my intent to bring up new, and I completely understand, and I don't want to go outside of that, so I'm going to be very careful. Unless the court has, I guess the last thing I'll say is, that was the preservation argument. So we did preserve the arguments with respect to the appropriate inclusions of alimony. Unless your honors have questions, I will tax your time no longer. Thank you.
I'll be brief. Julie Nelson on behalf of appellant Janae Rothwell this time. This is a very discrete issue and it has to do with a stay in a divorce case. I think the big picture is pretty well established. The estate was $28 million. Mr. Harris has represented here that he thought that it should have been $18 million. Even so, if it had been $18 million, then under Mr. Harris's own calculation, Ms. Rothwell was entitled to $9 million. But he's prevented her from getting any of it while we.
I mean, is it that simple though? Is it just simply a dollar for dollar kind of equation, metric along those lines?
No, I think it should probably be higher because we're talking about loss of use, loss of ability to enjoy, to protect her against damage. And damage isn't just waste. I mean, waste is the obvious example, but he's got all the cars. She was supposed to be awarded the cars. Those are depreciating. Just even if he's taking great care of them, they're depreciating. And so by the time they finally get handed to her, they're going to be worth less than they were at the time. So I think in a divorce case, it probably should be higher because you put her in a worse position than she was when she was married. When she was married, she was half the owner of that. She could use it. She could, take out a HELOC if she wanted. But she's been awarded the house, her house that she lives in. Nobody's disputed that. But she can't sell it. She can't, take a mortgage on it to refinance it. She can't, whatever she needs. And it's not even being challenged,
So
other than this cumulative error argument.
What I hear you saying is that what we should say is that there's something of a minimum threshold, that at a minimum it has to be the equivalent of the award.
Well, I think the rule already gives us that. The rule tells us that it has to deal with loss and damage and assure payment after the stay ends. That's all the rule requires. And our position was then and is now that the stay that has been ordered doesn't protect her against her loss, her damage, or assure payment after the stay ends.
Do we have a case that's that precise though, that says that it has to that as a monetary value, it has to be at that threshold?
Well, no, we have a presumptive amount, right? Which is the amount of compensatory damages plus interest plus costs and attorney fees. Now, I think there's an interesting discussion about whether divorce assets are compensatory damages, but that's not actually what we're doing here. But that's the standard, but that's not what happened here, right? We don't have that amount. I mean, if we're gonna use an amount, then there you go, that's your rule for it. And we don't have that here.
Was there any discussion in front of Judge Peterson that there should be sort of a piecemeal stay, in the sense of, yes, he has the right to appeal, yes, he's appealing, we understand that maybe things aren't gonna come back exactly the same. At least let her give over the title to the house, at least, give over the cars.
Right.
Then she can bear if there is, if something comes back against her, she can bear that loss.
Right, and our reply brief lays out all the different requests that were asked for, so we can go back there and look and see exactly what was requested. But to me, that's what should happen.
It wasn't all or nothing.
No, and that's what should happen, and if it's not what happens, then you've got to at least get to the compensatory damages standard, and in my view, it's higher than that, because loss and damage and assuring payment is higher in a divorce case than it is in a compensatory damages case, because you're also dealing with loss of use of enjoyment. I mean, we heard Mr. Harris talk about how the period, in his argument about the period between separation and divorce, they were entangled financially, but really, or they weren't entangled financially, they should have been able to do their own thing. I would suggest that that wasn't true then, but it should be now. They should not be entangled financially now. They should be able to go and do their own thing now, but they're not, because of the way that the stay is set up, and the stay doesn't adequately compensate her or adequately protect her.
Can I just lead you off the question? Is Ms. Nelson right about that? That at a minimum, there has to be a threshold of like, here's the amount that you were given in the divorce decree, so this has to be the floor for the bond?
Aaron Harris, sorry, I just want to make my
Yeah,
points first.
thank you.
Aaron Harris from
Sorry,
Smith
Jessica.
LC for the applicant. No problem.
Now
Thank you, and I
ask
appreciate
question.
that.
Yeah.
So, if I understand Your Honor's question correctly, what Your Honor is asking is, does the trial court have to have a minimum security
Yeah.
that equates to the value of the marital estate that has been transferred?
Yeah, or is it at least presumptive?
Okay. So, Rule 62 doesn't contemplate that type of a analysis. And with respect to what Rule 62 expects, you have, what is the form of the supersedeas bond and what is it going to do, right? And we have the rule which says, when an appeal is taken, the appellant by giving a bond, or as we see below, other security, may obtain a stay, and that effective is stay when the bond is approved. So the question is, what does the court in this case, or in a divorce case, have to consider when approving the bond? I think that's what Your Honor's asking.
Yep.
What elements go into that consideration? And I don't believe in Rule 62 it specifies anything other than what we would see in subsection I, which is, as Ms. Nelson pointed out, expected to ensure the value of what's been awarded plus interest plus attorney fees. Now, in the 2DP Blanding case, which the trial court relied on and which was briefed significantly before the trial court, that case was, how do we get a stay with respect, well, it wasn't that case, but the case's concept was, if you have a non-money judgment, you still go get a stay to keep the status quo. And that status quo language is from the diversified holdings case. So the Court of Appeals, when considering previously Rule 62 appeals with respect to the stay, says the goal is keep the status quo, which is the same goal as Rule 109 of the Utah Rules of Civil Procedure that apply to domestic actions. And what Judge Peterson did was he said, okay, we have a money component and we have a property component. What I'm going to do is make sure that the money component is appropriately assured for payment over the next 3 years, and put in an escalating pay-in structure that matched the promissory note or whatever we call those installment payment requirements of the decree. Mr. Rothwell complied with that, and he has complied with that. And then the court said, for the rest, for both sides, it's a status quo.
But is it a status quo though? Because Ms. Nelson's argument about that is that if he's still allowed to use the vehicles, for example, they're depreciating every time he drives them or rides them. So is there really a preservation of the status quo there?
Sure, and the reason that there is a preservation of the status quo is because Mr. Rothwell is specifically required to, as it says, sorry, I'm getting back to the order here. All involved assets, liquid or non-liquid, not be disposed of or encumbered in any way by either party.
But isn't disposed of or encumbered different than used?
Yes, and then the next sentence is, the court is confident that the separate order regarding non-disposal and non-encumbrance will preserve the status quo pending the outcome of the appeal. And what I think the court was trying to do is,
But
preserve
that
this-
seems to leave unanswered the question that she's raised in response to that argument, which is with respect to just use the vehicles as the example.
Sure.
If he's still allowed to use them, they are depreciating by virtue of the fact that he's using them, thereby
Right, so-
changing the status quo.
So, I understand, and I think what the relief would be, if there is a demonstration that a Mercedes G-Wagon, which those don't depreciate very often, but
Fair.
that's the only depreciable asset that's been indicated to me. Real property goes up, all the other ones go up, but if the Mercedes G-Wagon cannot be sold for the amount given at the divorce decree valuation, then she would certainly be able to say, court, the status quo wasn't kept because I am now $8,000 short or $12,000 short or whatever. And so give it back to me. And I think Judge Peterson would be very amenable to that type of a request and certainly would have every basis under the law to grant that request, to say, Mr. Rothwell, you did not preserve the status quo as I ordered you to do, and therefore you have to pay for the lost value of that status quo. I think that's the best way to resolve that. And it's the same paradigm that Rule 109 has. Rule 109 doesn't say stop using, right? Rule 109 says do not disturb the marital estate's preservation of its corpus. And then to the extent that there has been a devaluation of an asset between separation and divorce decree, that evidence is presented at trial when the court considers how to divide or how to create cash equalization payments. So given that there's no real discussion in Rule 62 of different types of cases versus different types of security, it just isn't there. What we have is the Court of Appeals has said three things. With respect to what is the goal of the security, that's the diversified holding case. Make sure that the judgment creditor is protected and make sure that the judgment debtor has the ability, if prevailing on appeal, to get back to where that judgment debtor would have been. That is the goal, right? And so Ms. Rothwell's argument has been, well, I didn't get to sell the house. I didn't get to rent it out. I didn't get to. Mr. Rothwell, if his Heber Ranch, for example, were sold during this appeal, he would never get it back. And that's the 2DP Blanding case. That's what happened. The individual wanted to buy the property, and by the time he had the option to do it, it was gone. And he was upset, and the court said, you didn't ask for a stay, sorry. And that was the correct ruling. So the judgment debtor's interests are preserved in these appeals. That's the whole point of Rule 62. The judgment debtor has to pay for the protection, but they are entitled to the protection. It is a significant due process interest that any litigator or litigation party has when knowing that if I go to appeal, I need to be able to have an appeal that's not a Pyrrhic victory. And that's the whole point. So that's two. Three, then, we go the American case. That American case is the domestic case in which a wife was unhappy with the fact that she didn't have specific timelines for getting paid off of half of the business valuation. The court said, you're just like any judgment creditor. Go use your judgment execution options. The flip side of that is, if husband didn't want to pay because he thought the business was overvalued or whatever, he could have gotten a 62 stay, and wife would have then been assured of the $75 or whatever $1,000 it was, plus 3 years of interest, plus the attorney fees that would have been spent to go vindicate her appealed interest in that property. So that's the case law we have to work with, and it's really very sparse. This is, I will concede, an issue that I don't believe has ever been brought to the Court of Appeals before, It was an issue Judge Peterson struggled with because there was no real case law. Frankly, if you read Judge Peterson's ruling, he tried as hard as he could, I believe, to just go straight down the line and say, what does the rule tell me? What does the case law tell me? Where can I go? And I think he stayed as close to the line as one would expect a trial judge to do, given the guidance that is there. If this court believes that domestic cases have some special extra, I won't say it that way. If this court believes that domestic cases need to have a different threshold, then one of two things happens. Your honors make the rule, or the legislature goes and fixes it. But I don't believe that there is anything in the case law that exists and that is indicated in Rule 62 that constitutes any error or misstep by the trial court, because the trial court had a limited box and functioned within that limited box about as straight as one would expect, given the discretionary nature of the decision to affix a security. And really, it's the trial court has to undertake what is it that's going to be adequate to preserve the judgment creditor's interests and the status quo when we're talking about property. The court took motions and said, okay, the way I read 62, Mr. Rothwell is entitled to a stay, but I don't know yet how much he needs to pay, and I don't know yet what the structure is. So give me supplemental briefing on that issue. We'll come back and we'll talk about it again. And so that's what happened. So the judge took both sides' arguments, and the judge made a discretionary decision within the Rule 62 bounds of what do I think, given what's been submitted to me, should happen with respect to the money and the property. And the trial court was faced with Ms. Rothwell's complaints that she couldn't sell the property. And of course, if that's the ability that a domestic party in an appeal would have, is to sell property out from under the appeal, that's absolutely not appropriate. That just can't happen. Mr. Rothwell would never get his ranch back or his Highland House back. That just wouldn't happen. So the trial court said, I'm not going to let her do that. What do I have? I'm going to make sure nothing gets sold, nothing gets transferred, the status quo prevails with respect to assets, and on the money, the escalating pay-in, which if this court remands and she has a cash equalization payment of the same or even less, the money's right there and it will be paid with the interest that was gained. And I will say, this entire appeal, Mr. Rothwell has been paying the to the penny alimony amount awarded. So to the extent there's any argument that her standard of living has been damaged or limited, that's just not true, because he has paid the alimony. And I think to the extent the court looks at what are the lines of a divorce case, what are the differences of a divorce case versus others, I think that's one indicator of how a party that's a divorce decree creditor can be protected during the pendency. If there's a support award, child support, alimony, whatever it is, that support award should continue. And Mr. Rothwell understands that. We offered that, and that's what the court expected Mr. Rothwell to do, and that's what he's done. And frankly, if Mr. Rothwell had come to the court and said, I don't like my alimony award, I'm going to keep paying the $20,000 and not more, I think that would have been unfair. And I think the trial court probably would have said, no, you don't get to do that. Because we have now established a standard of living. For better or worse, you may not agree with it, but for the time being, this is the standard of living that she's entitled to live and that you have to pay. And frankly, if the court would have said, no, you don't get your $20,000 as agreed, you have to pay whatever the number is, I think that would have been well within the court's discretion to do. But Mr. Rothwell recognized that that was most likely the outcome, or at least a very anticipated outcome, and wanted his stay and offered to pay that and has done it. So, as we pointed out in our appellee brief, the complete kind of compartmentalization of the alimony piece in the original appeal really does not do justice to the scope of the stay that was granted by the court. It expected Mr. Rothwell to pay to maintain Ms. Rothwell's lifestyle throughout the appeal, and that's what's happened. So she has been, as far as the court can ensure during the pendency of this, just like as far as a trial court can ensure during the pendency of a divorce case itself, when Rule 109 is in place, so you can't go sell stuff, but you do pay temporary support, it's the same concept, and I think that's a good structure for the trial court to have used in this case. And if this panel decides there needs to be some clarity with respect to domestic action specifics in stays, to me that seems like at least a good starting spot. Will it be perfect? I don't know. Nothing's ever perfect. Will it even be adequate? I don't know, because this hasn't been tested very much. But to the extent trial courts should be given guidance on this, given what your honors see happen in this case, then I think that's a good place to start. So unless there's questions, I'll stop there. Thank you.
Thank you, Mr. Harris.
I'm glad that Mr. Harris brought up the standard of living and the status quo. The status quo and the standard of living was that they had $28 million. And Janae's standard of living is, after the divorce decree was entered, was that she had $21,000 a month and he had $101,000 a month, and they both got $14 million. That's not where we are now. Where we are now is she gets $20,000 a month and he gets $100,000 a month and $28 million. So we do not have the status quo. I'm not clear what Mr. Harris is concerned about her selling the Heber Ranch. The Heber Ranch isn't at issue. She's not living in the Heber Ranch. She's living in her own house, which he hasn't even touched in his appeal, other than the cumulative error issue, and she can't do anything with that house, but it's very expensive to maintain, and she has no option but to keep maintaining it until she can afford to get out of it. Sell it, whatever. He hasn't transferred the deed to her so that she could, say, downsize it and pay her attorney fees, something like that. She's unable to do that. So the standard of living and the marital case law that you have to put parties on equal footing to allow them to go forward, that is not what has happened here. And we don't need to amend the rule. The rule tells us we need three things. We need to protect against loss, against damage, and to assure payment. That's it. That's all we've asked for, is to protect her against her loss, that she is not able to enjoy. She's not able to use this money. She had half of it before the decree was entered, and now she doesn't. That's a loss. Her damage, which, as we talked about, includes her depreciation and any other waste that may happen, and to assure payment in the end. There's no provision here about his death, anything like that, to make sure that it is available. And Mr. Harris's suggestion is that, well, you know, if the Mercedes, which we haven't attacked its value at all other than our cumulative error argument, if the Mercedes is worth less, then she can just go back and do more litigation to get it. Why? Why not just give her the Mercedes? In the first place, we're not challenging it. It's her car. Just, you know, move it over. There should not be any reason that one party can just strangle the other party's assets. Now, we had asked for a supersedious bond in the amount of $9 million, or he should be ordered to deposit into an account with the court. That's the presumption, is that you deposit all of the money into court, and not that you deposit some of the money into court and you just hang on and keep using everything else. So in our view, we're not asking for a new rule. We're not asking for a significant change in the case law. We're asking for an interpretation of Rule 62 that enforces its plain language, the loss, the damage, and assures payment in the end.
And perhaps I ought to have understood this already, but I want to make sure that in your view, the language of Rule 62 as it is wouldn't be enforced if she's not allowed to sell or encumber the marital home at this point? Or
I'm sorry.
are
Can
you
you say it
saying
again?
that Rule 62 would not be satisfied if she's not allowed to encumber or sell the home that she's in at this
No, it
point?
doesn't have to be that specific. That to me is one of the ways in which that is one of her losses that she is experiencing during the pendency of the appeal. Because if the appeal weren't happening and she had been given the deed to her house, then she would be able to sell it. That's an example of a loss, and she is not being compensated for those losses. That the opportunity cost, the things that are happening during the course of an appeal, that decisions that she might make, investments that she might make, hedging against inflation, things like that, right? All of the things that she would be able to do if she had the assets, she doesn't have the ability to do those things. Those are her losses, and she's not being protected against those or compensated for those. Thank you.
Thank you, counsel. Sorry to take up so much of your time with all of our questions, but thank you, you both. Just want to compliment you both on your appearances today. We think it's very appreciated. We will take these matters, both of these matters, under advisement and render a written decision as soon as we can. So I know these issues are important to your clients, and we'll hope to proceed with all haste.
Thank you.